Good afternoon, everyone. We're just going to give it a minute or so just to make sure that everyone who's waiting to come in has entered, and then we'll start. Okay, well, we'll make a start. Hello and welcome to today's webinar entitled, Is the Public Sector Equality Duty Dead in the Water? I'm Shushan Liu, a member of Doughty Street's Public Law team, and I'll be chairing today's webinar. We've got two brilliant speakers today, Donna Green and Zia Naibi, who will be providing us with a critical analysis of how the courts have approached challenges to public authority compliance with the public sector equality duty. As many of you may know, the PSED came about when the Equality Act was consolidated in terms of three pieces of anti-discrimination legislation: the Race Relations Act, the Sex Discrimination Act, and the Disability Discrimination Act. Each of these acts had contained a provision which imposed similar public sector equality duties in relation to race, disability, and gender, respectively. The race duty was the first of the duties and was a policy response to the Macpherson inquiry into handling of the police of the murder of Stephen Lawrence, which concluded in February 1999. He described as institutional racism the potentially discriminatory or unequal effects of an institution's policies and practices if they remained unexamined and unchallenged. The Macpherson report concluded that it was incumbent on every institution to examine their policies and the outcome of their policies and practices to safeguard against disadvantaging any section of our communities. The public sector equality duty was a product of that important inquiry, and it's meant to press public authorities to think proactively about how they comply with equality's duties instead of reacting when something goes wrong. The question that our speakers today will be looking at is whether this objective has been realized, or whether over time, the courts have allowed too much deference to ministers and local government as to the standards of compliance. Donna, who will kick us off today with a look at recent case law and a critical look at the future for the PSED duty, is a member of the public law team and has a special interest in discrimination law with a focus on community care and migrants' rights. He also regularly advises organizations and individuals on their rights and obligations under the Equality Act. He acted as junior counsel in the Court of Appeal in the challenge to the government's self-employed support scheme brought by new mothers who alleged it discriminated against them on the grounds of sex. He also acted as junior counsel in the challenge to the Home Office policy of actively evicting destitute asylum seekers during the pandemic, which resulted in the government withdrawing the policy and accommodating thousands of migrants throughout the pandemic. And before I turn you over to Donna, there's a Q&A function in the webinar. So please do ask questions as you go along. I will be collating the questions and we'll save questions after both speakers have spoken. If there are things that you wanted to raise and share in terms of anecdotes or experiences, please also feel free to use the chat function. Thank you very much. And over to you, Don.
Thanks, Shushan. So Ray, could you go to the next slide, please? I'm going to try and make this useful, as well as allowing a place for me to vent my anger a bit about the deficiencies in the public sector equality duty. So I'm going to give a brief overview of it, look at some recent case law, and then give some examples about whether it's dead in the water, and kind of look outside the law as well about how the kind of certain circumstances or the current circumstances we're facing and what role the PSED plays within the framework of holding the government to account about discrimination and ensuring that discrimination protections are set to a high standard. So I'm going to do a very brief look at the actual public sector equality duty, and I think the slides will be passed around after. So Ray, could you do the next slide, please? So I wanted to look at this and kind of look at the language of it as well. Shushan's already given a bit of background about how it came to be, but it's important, I think, to look at the words that I've underlined. So looking about how this is conceived as a need to eliminate discrimination, to advance equality of opportunity, and to foster good relations. While the due regard provision almost softens it a bit, it's being seen as a need that the government needs to fulfill. And that's really important. It's really progressive. It's different than the rest of the Equality Act, which is reactive and helps enforce discrimination through coercive measures and enforcement in financial penalties. But this is requiring government bodies to actively think about how this is a need and an aim within themselves. It sets the agenda for government in many ways when it is doing anything. However, perhaps it's not always borne out in the reality. Could you have the next slide, please, Ray? These are just what those points mean. And the next slide, please, Ray. And they're within the whole entirety of the provision. And the next slide, please, Ray. And then there's a direct acknowledgement in one of the provisions under section 149 of the Equality Act that it might involve treating some people more favorably, but there is the kind of classic caveat that it shouldn't be beyond the act and you shouldn't be discriminating positively except where allowed. And that's perhaps a more detailed talk for another day. Next slide, please, Ray. Importantly, also to this to section 149, when we're looking about its efficacy and whether it is dead in the water, it's helpful to outline the various exceptions. I view one of the most important ones is possibly immigration function. Immigration function of government is inherently based on nationality and race. It entails discriminating in those bases and how you let people into the country, who you let into the country, and who's allowed to remain, and various factors like that. And so it would almost be impossible to have a function within this means if you didn't do this, if your intention is to have an immigration system in the way that it currently functions. Next slide, please, Ray. So as Shushan's already said, the Race Relations Act was the real first forerunner in relation to the public sector equality duty. Next, so this is a quote taken from Karen Monaghan QC's book. If you go to the next slide, please, Ray. And you can read this if you get the slides after this. You can read about what Shushan has already put into. But it's important to look at that it was meant to mark this new change in the law. It was meant to move away from what I was saying about the fault-based system, but look more proactive. And it's in this context where the government, where the police force were particularly failing in this regard, to have regard to the need to erase these things and to be proactive in how they were policing, if such a proactive stance can be taken. Next slide, please. And so the important thing to remember in the context of the PSED as well, and which is repeatedly emphasized by the courts, is that it is a process, not outcome. In my view, this is one of the first ways in which we have a bit of difficulty with seeing the PSED as being a way of recognizing the need to foster good relations and eliminate discrimination, because you can quite simply look at all these things and look at the problems that you're going to create through a measure and have to face this PSED and still come to the outcome that you're still going to go ahead with it. Now, when you get to the courts, it can look different, and we'll go through a bit about what that looks like, and Zia, we will provide a bit about its utility and how it makes people stop and think again and change their mind. But in its essence, given that we're looking at the substance of the decision and not necessarily exactly what the outcome would be, it does weaken the protection for discrimination in a way that is less strong than you would want from something that is born out of this history of trying to eradicate, in effect, institutional racism. Next slide, please. And so one of those interesting cases that initially was born out, it was prior to the Equality Act coming into force and was brought on a challenge on the basis of the 3 existing public sector equality duties, so about race, sex, and disability. And it was challenging specifically the increase in student loans. In the equality impact assessment, there was a specific reference to socioeconomic inequality and how it would impact those individuals. Now, I don't need to explain that that is not one of the protected characteristics, nor was it one of the public sector equality duties. And so then Mr. Jonathan Swift QC, as he then was arguing that it was a proxy almost, that socioeconomic duty of course included looking at race and disability and sex. However, the court didn't accept that. It didn't accept that it was sufficient to consider the specific circumstances of individuals when looking at this. Yes, many of those people may fall into that category. And in fact, the court in a lot of its early case law accepts that if you're an ethnic minority or a disability or perhaps or a woman, you're likely to fall into a lower socioeconomic character, which is quite stark considering where we maybe are now. And yet it still says that it didn't consider the specific challenges that would arise in that. And so it did hold that it was in breach of the public sector equality duty, but it does in such a caveated way, and it kind of gives the first indication of when things are looking more deferential towards government, because the background to this case looks at other public sector equality duties such as bracking, and those of you who are very familiar with the public sector equality duty will know about the rigorous standard that you're meant to direct your mind directly to it. And yet this is a slight move away from that, where it talks about the administrative chaos in changing what would be the regulations to increase student loans. Now, admittedly, there was a desire to quash the entirety of the student loans regulations, which would have also damaged a lot of the benefits that individuals were going to get as support. But it's looking at this kind of beginning to get a bit differential even before we started. Next slide, please. And so I would posit that we're in this similar situation where we have the Section 19 1B Human Rights Act statement of compatibility, where a minister can indeed say, look, this legislation is not going to be compatible with the Human Rights Act or this rights guaranteed by this. However, where we think the House should still go ahead with it. Now, I don't know I don't know if that's been used, and I would want query why it would be used, because it'd be quite easy, any legislation would be struck down by the court as incompatible if there's an open admission of it, and you'd be able to mount quite an easy challenge, I would suspect. But is this similar parallel between the public sector equality duty, where you can look at all these things but still kind of turn a blind eye to it because you have decided upon this legislative framework and this is what you want to do? And you see that sometimes in the reasoning of public bodies. Next slide, please. So I'm going to help this to be, rather than just giving off about the public sector equality duty, I'm going to go through a bit of case law to give us a bit of practical look at this and kind of critically examine this. So a recent case is about this 3 million case. Now, there's many 3 million cases who are challenging how we deal with a post-Brexit world and what we do with the millions of the 3 million EU citizens that are in the UK. And this was regarding a challenge to the digital-only proof of immigration status. And it was saying this was going to discriminate against people because it was requiring them to have digital proof. However, and it was said that it was also in breach of the public sector equality duty. Now, the court refused permission because the digital-only proof had not yet come into force. And so we had a situation where you could show that there might be a disparate impact and there might be discrimination. And yet, because it hadn't come into force, the timing of when the public sector equality duty would be breached wasn't breached in that instance, or at least wasn't arguably even breached, because you currently had a system in which you still could give your paper copy, and so it wasn't hurting anybody at the time. And it was said that this argument was highly artificial. And it is difficult when you think about the rigor that's to be applied to the public sector equality duty, about the need to eliminate discrimination and the need to foster good relations. You aren't doing that if you're waiting for the moment where a problem will arise to be proactive. And so, yeah, I would question whether that shows us that the public sector equality duty is of utility in this instance. The next slide, please, Ray. This one is one that I've titled a Venn diagram that's a circle. We have about the NRPF scheme. So if you're applying for leave to remain in this country, you will be automatically given conditions of no recourse to public funds, except in some certain circumstances. But a child, ST, challenged this scheme as discriminatory and that it was unlawful. Now, what is really stark in this evidence is that the court accepted that more than half of NRPF conditions were imposed on nationals of countries from sub-Saharan Africa, an overwhelming amount of people when you consider the broad policy that is introduced on a lot of people, and that nearly half of the applications were by single mothers of British children, and almost all of those applications to remove the conditions where they were facing destitution were being granted. And so you had a kind of question about why this policy was being put forward in the first place and why it was continued to be enacted when there's, I would argue, prima facie discrimination in that you've got the Venn diagram that is a circle. However, the court still found that there was no breach of section 149. This was in part because, as I said earlier, you've got the immigration exception, but also the Secretary of State didn't keep any data on colour, and the court was quite willing to accept that it didn't need to, that it might be impractical or whatever it is. Now, that seems to fall foul, in my view, of a duty of inquiry. It seems to also not really accept the reality that the amount of sub-Saharan African people who may be of one color or a different color might be more overlapping than is the Home Office is trying to acknowledge. The reality of Black British children in the UK who suffer in extreme poverty because of this policy is well evidenced throughout the judgment, and yet the court was not willing to find discrimination in that view, or that the section 149 duty was failed to be complied with, despite the actual impact equality assessment or the equality impact assessment, noting that there was an overwhelming amount of people who fell within what would be protected characteristics. It was held to be unlawful for other reasons under Section 55 of the Border, Citizenship and Immigration Act. And so in some ways, there's nowhere to go beyond this, but it is helpful that it was indeed struck down for another reason. Next slide, please. Right. I'm just highlighting these two very briefly because I want to get on to my kind of forward-looking thing. So it looks about the continuous duty, and as I was talking about the 3 million case, and this is a case involving the environmental measures to reduce traffic in neighborhoods and brought by individuals who are saying that it discriminates against them, and there was no public sector equality duty fulfilled in these instances. And in the court, in those cases, there are references in the cases where you can look at what the court said about a continuous duty. So it's acknowledged it's a continuous duty, but it almost breaks it up into stages. So before you bring in the policy, you can look at it and you might not see any problems, but when it actually comes into force, you might see new problems. And again, I would go back to the 3 million point about it not being sufficient when you think about what the duty is meant to be and how the highest standards it is meant to, what the high standards it is meant to achieve. Next slide, please. And so if we have this background of the public sector equality duty looking at erasing institutional racism and it being the very aim of the duty and part of what the courts weigh in the balance when they're thinking about whether a public sector equality duty is breached, we have the much derided Commission on Race and Ethnic Disparities report, which, if in effect held that the country is still institutionally racist, is no longer a situation that exists. It is saying on evidence that has been criticized as being biased and skewed, that it no longer exists. And so when you think about how government ministers could then approach this, what incentive is there to eliminate discrimination or foster good relations if everything is perfect? What is the role of the public sector equality duty if the government's own report, commissioned, allegedly independent, is in this situation where we have no such need for it, is what the Commission report may not have acknowledged that it was saying, but indeed was saying indirectly when considering the broader body of evidence that it was looking at. And it's also contrary to other government reports. It's been said by many people. I've just put two there for completeness. And we have a situation where if you want to look at the example of voting IDs, if we're looking at whether introducing identification for voting, whether that will be what is in the balance in that situation, you have reports which indicate that you shouldn't have to weigh race in that, which would be extremely worrying given the risk that it poses to, I think it's 11 million people don't have a photo ID to vote with. Next slide, please. I include this last slide just because it's one of the interesting things that many people will have seen in the news recently when there was the Home Office were seeking to deport some migrants over the summer, and there was a huge groundswell of community support for these individuals who were local in the community and known about by their neighbours. When you think about what fostering good relations looks like, you see the solidarity being expressed by these people with their neighbours who happen to be migrants. And indeed, ultimately, the decision was not made to release them on the basis of the PSED, but on the basis of purported public health grounds, which is somewhat ironic and interesting. And So I would just wonder about the role of the PSED in everyday life and how we do that in terms of fostering good relations between people and eliminating discrimination when the state has this sort of get out of jail free card to look at the inequality impact it's making and choose to still do it anyway. Thank you very much.
Thank you, Don. That's fantastic. Our next speaker is Zia Nerbi, who probably needs no introduction. He is an experienced specialist, public law and civil practitioner, and a leader in the fields that he practices in, including homelessness and housing, community care, children's rights, and education. He is also regularly instructed by the official solicitor and local authorities in court protection cases involving deprivation of liberty, residence, and capacity disputes. He has been involved in key cases at all levels, including the Supreme Court and the European Court of Human Rights, and has also been involved in many strategic test judicial reviews. Zia is going to look at the way in which the PSED has been used and considered by the courts in the housing context. Over to you, Zia.
Thank you, Shin. Always slightly embarrassing to hear these biographies. I was wondering who that could be. Could I have the next slide, please? So I think the thing to bear in mind about the public sector equality duty is that it applies in the exercise of functions. It doesn't give a freestanding right of its own formulation, but it applies in the exercise of functions. What does that actually mean? Well, I was just perhaps a little more optimistically than Donna, that the PSED is a powerful tool. Firstly, it enables the court, if it's interested, to more closely scrutinize any particular decision. Secondly, it heightens the obligation on an authority when they're formulating their policies and then when they're implementing their policies. Thirdly, if a challenge is commenced, it requires the authority will have to show that it's had the due regard with reference to evidence. The courts have said in a number of cases that you will need some evidence to show compliance with the PSED. It also enables macro and micro challenges. So it allows a challenge to a policy on a macro level, but it also enables you to challenge a particular decision that affects one person. It affects how statutory provisions are interpreted. Now that's perhaps arguably going too far, but yeah, I hope to show in this brief talk that actually how the court interprets, certainly in homelessness cases, statutory provisions is effective when it looks at those provisions through the prism of the public sector equality duty. And finally, the court's always very clear to tell us that it's not a duty to achieve a result. However, it can and does alter the substantive outcome of a decision. So even though it's only a steps duty, it can have a substantive effect. May I have the next slide? Now, Donna has very helpfully gone through this already, and we can't get around the due regard, but it is mandatory to have due regard. And in particular, not only must you have due regard to need to eliminate discrimination, but you have to have due regard to need to advance equality of opportunity. And what opportunity means is not defined in section 149. And therefore you can be creative. For example, in some cases, I've argued that the duty involves equality of health opportunity, although that is not specifically set out in section 149. Fostering good relations between persons who share a protected characteristic and those who don't share it. Well, there's not much case law on this, but for example, in a case where neighbors fall out, say in an antisocial behavior case, where one of the neighbors is disabled, the failure of a public authority to start mediation proceedings, or perhaps to educate people about what the consequences of disability are and why they're relevant to the behavior that's being complained of. Again, one could argue that the public sector equality duty is a key tool that can be used in such a case. So my bottom line, my view, these are powerful duties as long as you recognize what they're there to do. Could I have the next slide, please? And what does equality of opportunity mean? Well, it means removing or minimizing disadvantages. And it involves taking steps to meet needs of persons who share a relevant protected characteristic that are different from the needs of persons who don't share it. And again, what's important is that disadvantages is not defined. So again, once you are within a protected characteristic and you can show that this is a disadvantage that you suffer because of that characteristic, then the issue arises, well, what steps need to be taken to remove or minimize those disadvantages? Next slide, please. Disabled persons get a particular shout out. Although Section 149 covers a list of protected characteristics, Section 149 highlights where you're dealing with disability. And certainly my experience has been that where the protected characteristic of disability is engaged, the courts will often use the PSED when they seek to go behind a decision and to scrutinize it more closely. Next slide, please. May treat more favorably. Again, that is important. It's important where there's an exercise of discretion going on. So in lots of, certainly in homelessness cases, some duties are mandatory, but other powers are discretionary. So should a power be exercised in a specific case? Now, a lot of the case law on challenging powers is very hard because the courts have basically said, you leave it to the public authority to decide how they will exercise their discretion, and we will interfere only on traditional judicial review grounds. But this is 1496 is important because it may be as part of the exercise of discretion, one of the things that has to be factored in is that it might involve treating your person more favorably. Could I have the next slide, please? So, key points. It's a process, not a result duty, but it can affect the result. Now, it applies in the exercise of all functions. So it applies when you're drawing up criteria, and it also applies when those criteria are then applied in an individual case. And the reason for the PSED is that the parliamentary intention is that there needs to be a culture of greater awareness of the existence and legal consequences of protected characteristics. Next slide, please. And then these are again from cases, decided cases, still bind. Must be exercised in substance with rigor, with an open mind. So it's not a box-ticking exercise. But once it has been exercised, it's for the decision maker to determine how much weight to give to the duty. The court simply has got to be satisfied that there has been rigorous consideration. Now, the duty is on the decision maker personally. They can't assume that somebody else has already taken the public sector equality duty into account. So if they're making a decision in a particular case, applying a policy, they have to themselves apply the PSED in reaching their decision. And it has got to be complied with at all times. I think I've said that before. May I have the next slide? And you've got to have evidence on which to base consideration the impact of your decision. So you can't say, well, this policy will not have any negative impact on protected characteristics unless you've got the evidence to reach that conclusion. But bear in mind that in any particular decision, you don't have to give reasons as to how the duty has been discharged. The court can look at a decision and decide that the matters that are addressed in a particular decision mean that due regard has been paid as required by Section 149. And what comes out in a number of cases is that the court requires, where there's a PSED element, there to be a very sharp focus on the protected characteristic. And that plays out, certainly in homelessness cases, in inquiry-making duty, where it's arguable and is argued that inadequate inquiry has been made to satisfy the duty to focus very sharply on the consequences of a protected characteristic. And it's a continuing duty. So authorities may need to review their policies or decisions. And certainly my experience has been that reviewing isn't going on. And certainly some policies are a number of years old. And as we'll see in one of the cases, the authority had no evidence as to show whether or not a allocations policy had negatively impacted upon disabled households. May I have the next slide? So in homelessness, where did the PSED come in? Well, it comes in at all stages. It comes in as to how you determine an application. It comes in as to the definition of what it means to be homeless. You're statutorily homeless because accommodation is not reasonable to continue to occupy. The PSED directly impacts on that. It comes into any assessment of suitability. It comes into when you're deciding if a person is intentionally homeless or not. It comes into vulnerability. So when an authority is deciding if a person is in priority need or not, then the PSED has significance. Although following a recent case, I would suggest with all the various homelessness questions, vulnerability is where the PSED is the least likely to actually give you a substantive benefit. So the PSED comes into performance of duty as to how, when duty should be performed or how it's being performed. And as I've already said, it will come into exercise of discretion. For example, should interim accommodation be granted pursuant to a discretion as opposed to a duty? Next slide, please. So determination of an application. So it applies at all stages. It applies to what inquiry needs to be made. It applies to what needs to be taken into account. It applies to what the procedure should be on any review. Should any changes be made, adjustments be made to any standard procedure that the authority has. It applies to the decision itself, and it applies to performance of duty. Next slide, please. The statutorily homeless, the two subsections here. 1753 says that a person is homeless if accommodation is not reasonable for their continued occupation. 1772 says, but you can have regard when you're making a decision on that to general housing circumstances in the area. Next slide, please. So 2 cases, Lomax and Gosport, that was an applicant, she lived in a bungalow, she was isolated, she wanted to live near her support network. She said, I'm statutorily homeless because it's not reasonable for me to continue to occupy a bungalow. And the local authority said, well, we know it's not ideal, but there are lots of people not living in ideal accommodation, and therefore we think you're not homeless. And the Court of Appeal said that wasn't the right way to look at section 1753 and 1772 when the protected characteristic of disability was involved. And it sets out there, those bullet points, what a sharp focus was required on. And in particular, it said, when you're comparing her needs, you can't just say they're not ideal, but lots of people don't live in ideal accommodation, or that actually we've got a real housing shortage. The sharp focus requires that you've got to compare her and then compare her with the accommodation and needs of people without her particular disabilities. And if necessary, you've got to prioritize the disabled person. Next slide, please. And the Court of Appeal held that the reviewing officer had acted unlawfully by considering section 1772 without sufficiently focusing on the applicant, that failed to take account of the difference between her needs and the needs of others without her particular disabilities. Pointed out that a disabled person could be treated more favorably than a person who was not disabled. And this says this, had the reviewing officer had regard to the PSED, he would probably have reached a very different conclusion. I mean, that's as near as they're going to come, that the PSED would lead to a different interpretation of section 175, subsection 3. Next slide, please. So I'm not going to go through this, but in suitability cases, this is what the PSED requires. That's the case of Hackney and So again, if the decision that you have hasn't got that focus, then it is arguable the decision is unlawful because the decision maker has failed to have due regard to the PSED, because the review has to, or any decision on suitability has to take into account all of these considerations to demonstrate the necessary sharp focus. Next slide, please. And suitability also came in a case called Canon. Now, in Canon, what you had was a person who's given accommodation on a second floor, external staircase, shower but no bath. And he said, I need a bath, not a shower. And also going up and down the external stairs is causing me pain. And again, Newham said, well, it's not ideal, but we've got a real housing shortage. And the Court of Appeal overturned Newham's decision. They said that by looking at general circumstances, they'd failed to display the necessary sharp focus. And they'd also failed to do it by downplaying Mr. Cannon's problems. And that's what I mean by saying that the PSED allows the court to more anxiously scrutinize the decision itself, because it's considering whether the sharp focus is there or not. Next slide, please. Intentionality, the PSED is relevant because one of the tests of intentionality is if the act is deliberate, as well as whether accommodation is reasonable to continue to occupy. Well, I've already addressed reasonable to continue to occupy, but in terms of deliberate, the local authority has to make inquiry. Does it only have to make obvious inquiries? That's what the test is in normal cases. Well, in a case called Puretti, the Court of Appeal held, well, where you've got a protected characteristic such as disability, you've got to make an inquiry as to consequence of that disability, not only where it's obvious, but where it's possible that it could make a difference to whether or not an act was deliberate or not. So it reduced it either heightened the duty of inquiry, or it said this is a specific duty you've got to satisfy of inquiry under the PSED, and therefore you've got to make an inquiry whether it's obvious or not. Next slide, please. And that's Puretti there. Now, the recent case of Ibrahim in Westminster City Council is interesting because there, Mr. Justice Sewell talked about the issue of subjective reasonableness. Now, which is, if a person leaves property because they say it's not reasonable for me to continue to occupy, but it is objectively reasonable for them to continue to occupy that property, how does the PSED work? Well, the court said it works in this way. It affects the issue of whether the person subjectively believed that the accommodation was not reasonable for them to continue to occupy. And if that is right, that can then affect the ultimate question of whether that person is intentionally homeless or not. So Ibrahim and Westminster is an important and interesting case. Sorry, I'm whizzing through these. We've got a fairly short time period today. Next slide, please. Now, vulnerability, I can really do this quickly. I think with vulnerability, it's fair to say, I wouldn't say it was dead in the water, but I would say that you really are clutching at straws in a priority need case where you're relying on the PSED case to assert a lack of inquiry for vulnerability reasons. Could I have the next slide, please? So performance of duty. Now, this I think is interesting. So in El Kundi and Birmingham City Council, one of the things complained about was that Birmingham had effectively a list on which they put everyone who was waiting for accommodation once the main housing duty had been found to be owed to them. And what the court found was that by just having that as a waiting, as a queuing system, that failed to have due regard to the PSED by failing to realize that some people have been waiting less time, might still need to be treated more favorably than others because of their protected characteristic and needed to be accommodated sooner. So that's El Kundi. Next slide, please. Now, discretion and interim accommodation, I think that speaks for itself. You have to take the PSED into account as a relevant factor when exercising discretion, when deciding how long an intentionally homeless person should be accommodated. and also deciding whether discretion should be exercised to make a referral to another local housing authority. PSED is relevant in all three of those, and if the local authority hasn't looked at it, that decision is unlawful. Next slide, please. And homelessness strategies. I've got a bit of a bugbear about homelessness strategies. So they acted in 2002. The local authority is under a duty to formulate a homelessness strategy. What that means is they've got to think ahead as to what accommodation they're going to require. People who will be or may become homeless. And then they've got to have a strategy to inter alia secure that sufficient accommodation is and will be available. Next slide, please. So you should always get the homelessness strategy for the authority that you're litigating against in a homeless case. Work out how the PSED fed into the drafting of the strategy, particularly with disability. How are disabled people treated by the strategy? I have seen homelessness strategies which make no reference to disabled persons at all, make no reference to the Equality Act. What attention was paid to the procurement of stock when thinking about the need for adapted accommodation for disabled persons? And how is the effect of the strategy on disabled persons kept under review? There seems to be in many authorities no review, ongoing review at all. But if you then judicially review an authority for saying, well, you haven't provided us with suitable accommodation pursuant to your duty, and they say, well, we're being asked to do the impossible. Well, why is it impossible? Because their homelessness strategy hadn't thought ahead sufficiently. I know that I just put that up there for consideration. Next slide, please. And I'm going to quickly go into this because I think we're running out of time. So allocations, the PSED does apply, obviously, to allocations policies. So in H and Ealing tried to give priority to people who are working in its scheme. And it was argued, well, look, disabled people are less likely to be able to satisfy that criteria. And the court found, well, there'd been an initial failure to comply with Section 149 by failing to provide a proper equality impact assessment, because there'd been no analysis of the number of non-working disabled people who had been overtaken or at risk of being overtaken by working people lower down the same priority band or on a lower, or if they were in a lower band. So the PSED meant that the allocation policy needed to be looked at again. Next slide, please. And Ward in Hillingdon, this is where Hillingdon tried to put in a 10-year residence requirement to go on to their allocations policy. And they were challenged by inter alia some travellers who said, well, look, we travel from authority to authority. We're unlikely to have the 10-year, to be able to satisfy the 10-year residence requirement. And what the court said was, well, compliance with the equality duty requires a duty, involves a duty of inquiry. And although you'd have to look at every single protected characteristic or every single situation, once a challenge is made, the authority should have considered its position in respect to the protected group, and the failure to do so was a breach of their duty. This may allow you to deal with some time points where authority says, well, you're simply too late. Well, if the policy doesn't address the protected characteristic and then a challenge is made, you can argue at that point, the authority needs to address it head on. Next slide, please. So Noor and Birmingham. Now, in this case, which dealt with a number of issues, the court found that the equality impact assessment couldn't be criticised for not foreseeing every single problem that could arise from the operation of the policy of its allocation scheme. But, said the judge, the council never reviewed how the policy was working in practice, didn't undertake any analysis to see how it was impacting people with protected characteristics at any time after it became live. And so the council had been operating a scheme without knowing whether in practice the scheme achieved the objectives which it very proudly said it was trying to achieve in its introductory paragraphs. Next slide, please. And it said, the judge said this, one of the purposes of PSED is to ensure that unintended discrimination is identified by a public body before it results in individuals with protected characteristics from suffering adverse outcomes. And the council in this case accepted that because they weren't keeping any records, it was very difficult for them to demonstrate that they discharged the public sector equality duty. Next slide, please. Right, so that's it. I'm sorry for such a quick whiz through. We wanted to leave some time for questions and answers. But my summary is very simply, in homelessness and allocations cases, the PSED is a powerful tool if used correctly. And I'll hand back to Shushan.
Thank you very much there. I was wondering, just looking at the questions and answers, and I think there are no current open questions. So I actually have a question to get us going. Can I ask Donna this? In relation to the PSED, are there concerns that you have about the way in which the courts are dealing with relief and remedies as well? Because I mean, there have been a couple cases in the last few years where even where the courts have made a finding positively that there's been a breach, they haven't really granted any relief in relation to the PSED. And I just wondered whether, you know, in the context of our title, is the PSED dead in the water, how that fits into that.
Yeah, I think, you know, Zia's given us a really good overview of recent case law where it has been important and it has worked. And I think it almost feels like a bit of a lottery or a mixed bag. And it's when you look at the kind of broader governmental strategy that sometimes you can see quite a lot of deference. It's that kind of point that I was talking about earlier about the administrative chaos that they're so concerned about. But also we're seeing a lot of highly likely cases. So the Section 31, sorry, I can't remember off the top of my head, but of the Senior Courts Act about relief being refused because it's highly likely that the outcome would have been the exact same. So I think in a case called Blundell recently about deductions from benefits being taken to pay off criminal fines, although it was held that the policy fettered the Secretary of State's discretion, they refused relief on the public sector equality duty ground because it's likely that they would have still taken the exact same decision. And so I would say that when you look at it like that, when you're trying to think of what is going to foster good relations, eliminate discrimination, if the court is kind of saying, well, we're not even going to make you do anything differently, we're not going to make you face up to anything more, then you are in a situation where it can just end up leaving the claimant with no real remedy in those circumstances.
Yes, no, that's quite right. Zia, I know, you know, in so many aspects of housing law, the PSED has played a really important role, and your talk really illustrates that. I wonder, in one area that you haven't touched on is the area of possession cases, where the courts have pushed back a little bit on Section 149 in terms of the Dodana case and other cases where it doesn't seem to be going anywhere as a bit of a defense to possession. And I just wondered what your views were on that.
Okay, well, I think first it's got to be borne in mind that in possession cases, you have lots of other sections of the Equality Act that assist. You have the is it directly discriminatory? Is it indirectly discriminatory? Has there been a failure to make reasonable adjustments? You have the Section 35, you can't evict if it would be discriminatory. So Section 149 really is at the back of the queue because you've got all these much more powerful defenses. And it's important to bear in mind that in a case called Stevenson and Birmingham City Council, the Court of Appeal said that those defenses, those substantive defenses, even apply in cases where an order for possession would be mandatory. So the PSED in possession cases should be doing a different job. And where I think the PSED is important is that where there's a lack of appreciation of the PSED, that affects the landlord's ability, the public authority landlord's ability to argue that eviction is proportionate. Because one of the things they have to take into account is the PSED. Now, for example, let's say you have an antisocial behavior case where the neighbors have fallen out. I think I said this at the beginning of my talk. And the reason they've fallen out is someone with a disability is displaying behavior that is causing a real nuisance to everyone around them. Well, the PSED requires you to have due regard to the need to foster good relations between persons with a protected characteristic and persons without it. Now, what did the landlord do then right at the beginning to foster good relations? If they did nothing, but at the end, carry out a proportionality assessment and say, because of the acts themselves, it's proportionate to evict this person, the PSED challenges goes to the very heart of that assessment. So my view, the PSED still is relevant in possession proceedings, but as I said, it does not give you a freestanding right. It's relevant to the exercise of functions. And if you use it in that way, I still think it has a part to play.
That's really, really helpful and quite an interesting way of looking at sort of the relationship between the PSED and substantive discrimination and how you can then use the two in a much more effective way. Thank you for that. Donna, there is a question in the chat, which is really, I think to just sort of distill it a little bit, is really about the relationship between a body that funds another organization, both being public bodies, where one body is known to, or allegedly known to discriminate against certain people with protected characteristics. So in funding decisions, how does that play out in terms of the PSED?
Yeah, I think you're similarly looking at what was the situation in Hurley in that case, where you're looking at what would you be trying to challenge and what is it that you're trying to challenge in the circumstances. So are you saying that in this case, I think it's the students' union, are you saying that the students' union in and of itself is breaching the public sector equality duty, or some aspects of it? Is there perhaps a policy that it's promulgating that you could look at? And so you're almost coming all the way back to looking at that. But you might also, if you were trying to challenge that kind of funding allocation, you might come up against the problems about, well, you should have challenged it way back when the students' union was being created. And so you're going to have a really difficult time of relief when you look at recent cases like Adiatu and Moore, which we were looking at legislation that was brought in quite a while ago. And it was only at the moment where the hard effects were being felt did individuals challenge it. And you would think that the court would almost reward this behavior, given the kind of points I was saying about the 3 million and about the continuous breach in the low traffic zones. And yet you have this kind of juxtaposition between the two positions. So it's quite hard to kind of advise the abstract, but those would be the kind of things that I would immediately think of.
I suppose one of the points that Zia really mentions and emphasizes in his talk is that the PSED is about the process rather than just about the outcome. So it's a due regard duty, isn't it? So it's a having regard to the relevant factors rather than determining an outcome that is going to be there. There's a question in the chat from Oliver Edwards, which I'm going to put to both of you because it relates to the work that you both do. So whilst the PSED doesn't apply to decisions concerning immigration status, does that extend to accommodation decisions, say under Section 95 of the Immigration and Asylum Act? I don't know whether or not, Zia, you want to take this first.
Well, shortly, I think it does, because it's to do with the suitability of any accommodation that's provided. And certainly I've used it in cases to argue that, for example, a person shouldn't be dispersed if they're receiving treatment at a particular institution. Short answer, yes.
Donna?
Yeah, I was going to say there's the recent case of DMA, which looks at Section 4, so the corollary about individuals who have had unsuccessful asylum claims. It looks at the failure that there was in that case to have a continuing review of whether the accommodation was suitable for those with disabilities. I should also say, when distinguishing immigration status and the immigration functions, there's specific acts that the immigration doesn't apply to. But also the immigration status was also held in Taiwo and Onu to not form part of nationality and race in any event. So you have two kind of hurdles if you're looking at immigration status specifically, just in this context.
Well, I suppose asylum support and the adequacy of the accommodation is not really so much about someone's immigration status, but really about whether or not they have a protected characteristic in the context of the accommodation arrangements. Right. I'm just going to check and see if there's any Oh yeah, so Oliver says, what is, oh yeah, you're going to answer that question on the case. So just in short answer, because we've got a few minutes left, you know, Donna, having listened to Zia's presentation, you know, think about what you started with in terms of yours. What would your answer be to the question that we were positing for today's seminar? Is the PSED dead in the water?
I probably wouldn't say it's dead in the water. I have to admit, I do use it as well, and I obviously use it properly. I don't ignore it because I think it's useless. I would say a good example of maybe it having become a legal formality outside the context of housing is ST, and I would recommend individuals to read it and on the basis of how that evidence is borne out and the kind of ultimate decision of it becoming a tick box exercise in some ways, but maybe not dead, maybe just awaiting resuscitation.
And Zia, I know you're very optimistic in your presentation, looking at all the positive things that the PSED can do, but obviously the case law kind of points both ways. And I don't know whether or not, sort of on reflection, what your answer might have been in terms of the question for today.
Well, I haven't changed my position, which is that it's not dead in the water. I think it is a powerful tool in the work that I do. You know, when you're, I have to say that the one time I came across her was where I was trying to argue race in the PSED and language. And I was dealing with a Syrian refugee who just arrived in the country, who had this long homeless interview, and who had clearly been adversely impacted by failure to understand what was going on. And we argued the PSED and race and language. And it was factually a very attractive case, but the county court judge wasn't having any of it, to my surprise. And then we renewed in the Court of Appeal. We sought permission in the Court of Appeal, and we were just simply refused permission. And you know, that was a salutary lesson, I think, that I realized that, well, perhaps I shouldn't go this far, but it may be that race and disability, and most of my uses of the PSED come in the context of disability. It may be that courts are looking at disability differently to race.
I think you're probably right about that. And also, I suppose one of the things that we were talking about prior to commencing this webinar was that, you know, it is surprising that even today we're still looking at what the PSED is, and public authorities don't appear to all consistently have a clear understanding of what it's about and what it's meant to do. And certainly when you look at public sector equality assessments, they seem to be, as Donna describes, those kind of tick box exercises that precisely you're not supposed to do. I don't know, I mean, when I first started practice, the equality impact assessments were a requirement in terms of publication, so that you could see in a very clear way that A, it's been done, B, how it's been done. But over time, you know, it has not needed to be a formal assessment and not needed to be published. And I don't know whether or not, just as a last parting thought from both of you, whether you think that that has contributed to these types of questions of what is the utility of the PSED. I don't know, Donna, do you want to go first?
Yeah, I think it's difficult. I think if you have that outward facing requirement that you're going to publish something and that you know that you're going to publish something and it has to be well reasoned, it just encourages good administration more than anything else. You have the case of Rowley about the woman who was D/deaf and the failure to have the transcription live for a lot of the COVID announcements. And on the day of the court, they rocked up with their quality impact assessment, and that was enough for Mr. Justice Fordham in the instance. And so it would have been better for this woman to have understood about how they made the decision, and just it fosters those good relations in her as it's meant to be.
And Zia?
Well, I agree. It would be better to have done it properly. And I'm not sure it's in the interest of local authorities not to publish it, because what it means is when you have a challenge and you say, well, what were the equality considerations that you take into account? Oh, and by the way, you need to evidence them. They can't point to a document. So in a case I did earlier this year, they were having to go back to minutes of meetings and what people believed to be that was being discussed at a meeting. And the court wasn't impressed with that. So, it's not necessarily just in the interests of applicants for these things to be done. I think it also benefit local authorities too.
Well, thank you very much. That was a really brilliant webinar, and thank you for both of your expertise. I hope everyone enjoyed this, and we'll be circulating the webinar PowerPoints in due course. Thank you very much for everyone for attending. Have a good day.
Thank you. Pleasure.